Legally Speaking with me, Tarun Nangia. Now, since the past few years, since the IBC or the Insolvency and the Bankruptcy Code and the NCLT codes have taken off, there has been a huge interest among the business community in this process. This has meant that a lot of companies have found new buyers. We've been able to save jobs. We've also been able to, in a sense, help the economy of this country through this process. And in this process, a new aspect that we saw in the past many months was the aspect of personal insolvency. Now, there is a lot of curiosity in the business community to know more about this. And that's why I thought, why not get a panel of experts who deal with these issues day in and day out. There are some new faces, there are some familiar faces who you see on the show today. But may I welcome Misha from Shardul Amarchand Mangaldas. It's a pleasure to see you again on the show. I also welcome Siddharth Srivastav from Khaitan and Company. He's on the show for the first time. Welcome, Siddharth. He's a new addition. Bikash Jhawar from Saraf and Partners joins us today. Bikash, a pleasure to see you. This is your first appearance on Legally Speaking. Hoping for some good interventions from your end. Ishna Kumar, you would have seen her on Legally Speaking earlier. Advocate Ishna Kumar practices at the NCLT and the NCLAT forums. Good to see you, Ishna. And first of all, we have to lay the ground for our today's episode on personal insolvency, introduction and examples. May I request Misha to open the show in about 2.5 minutes, if she could lay the ground on which we will move ahead, explaining the personal insolvency process.
Thanks, Tarun, and it's a pleasure to be back here with you. So personal insolvency, as you rightly said, is invoking a lot of interest in the industry for the businesses and bankers alike. So let me first start with the fact that IBC proposes a complete regime for the entire personal insolvency, but the entire regime is not in effect for now. Only the regime is in effect with relation to the personal guarantors to the corporate debtors under the IBC, which corporate debtors includes companies, LLPs, and which are covered under the Part 2 and who may have borrowed and may have defaulted. But it's a very unique case where you have, the personal insolvency enacted and in force, but only with respect to one particular category of all the, universe of personal insolvency related subject matter. So individuals, proprietorship firms who are not guarantors to corporate debtors are also otherwise strictly covered under the law, but that part of the law is not enacted. And this is what led to initially a certain uncertainty about the future of, personal insolvency under the IBC. And it culminated in a constitutional challenge before the Supreme Court of India. And the challenge was that the Ministry of Corporate Affairs, having notified the portion of the IBC which deals with personal insolvencies only with respect to personal guarantors, is without legislative authority and arbitrary. The Supreme Court of India in the Lalit Kumar Jain judgment delivered in May 2021 has settled that uncertainty, and that's the first success story in the personal insolvency regime, if I may say so, because it created a lot of uncertainty whether the personal insolvency would move forward or not. And the Supreme Court settled that issue, and the constitutional validity has been upheld. Now, I can go into more detail, but I'm sure we can take that up a little later in terms of what the Supreme Court held. But coming back to the process per se, the process is that under the personal insolvency regime as well, the creditors as well as the personal guarantor or the individual can initiate the insolvency process. If it is to be initiated by the creditor, then the creditor needs to issue a 14-day notice. And in case the personal guarantor or the individual doesn't pay up, then the creditor can move forward with an application to the NCLT. What's most interesting about the personal insolvency regime is that the moment you file the application, the interim moratorium comes into play. This is a very unique feature of personal insolvency as against corporate insolvency resolution process, where once you file the application and only after NCLT hears you and admits the application that the moratorium starts to run. And in my personal view, it leads to a bit of a problem because that interim moratorium only, protects the personal guarantor insofar as there can be no enforcement of debt against that personal guarantor. Neither can any legal proceedings be initiated against that person. But there is no bar on that person to deal with the assets. And I would think that the law should have been the other way around. There should have been a bar on dealing with your personal assets, and then bar on legal proceedings should have happened once the admission happens. Be that as it may, there is an interim moratorium, then the RP gets appointed, the resolution professional, and he gives a report to the NCLT or DRT, whichever may be the forum, and we can maybe get into when is, which forum, in which instance. But once that RP gets appointed, he has to give a report whether the application is genuine and deserves to be admitted or not. So in a way acts as an amicus to the adjudicating authority, and upon his report the action actually gets admitted. And that doesn't mean that as in a parallel to company process, it doesn't lead to immediately bankruptcy or liquidation. In the case of liquidation, it leads to a process of coming up with a repayment plan, and that's the process that the RP has to take forward, and only if that process fails that the individual goes into bankruptcy.
Okay, point well taken. Thanks for laying the ground and this introduction. I'll go to Bikash Jhawar from Sarafin Partners for his introductory comment on the show on the issue of personal insolvency. Bikash.
Yeah. Hi, Tarun. So, Misha's laid down the initial, how the process would start. And, obviously there is as Misha pointed out, there is a issue around the fact that currently only personal guarantors are the ones who can be subjected to personal insolvency. But hopefully in times to come, we will have, more immediate basis, a slightly more expanded personal insolvency application to include, individuals at a more, independent level, independent of them being guarantors. Why that would be also important is because currently there is, and in India, there is a very vast section of business which runs under partnership structures. And regular partnership, as we know of, not the limited liability partnership, but the regular unlimited liability partnership, those get covered only under the personal insolvency regime. They don't really come within the corporate insolvency resolution process. So a lot of those type of businesses, to resolve their debt, we would need, the personal insolvency law to start getting notified fairly shortly. So that greater, and that is what the business community would be interested in. Personal insolvency at a very individual level, may not necessarily be that helpful for either the banking community or for the business community, right? But it is their business ability to restructure their business in a more simplified, more statutorily recognized path, which is what would be of interest to businesses. And so I think the government should kind of now seriously look at notifying the personal insolvency regime on a broader basis. There will, Misha also raised a point around, which forum should be the appropriate forum. And that, according to me, is an important point to discuss. Because, and we can do it later, whether DRT is really even the right forum for personal insolvencies to be taken up, whether it has bandwidth, capacity,
Thank you, Bikash, for your opening comment. I'll go to Ishna Kumar. Advocate Ishna Kumar, your opening comment on this issue.
So As we're all aware that, insolvency law in India has been codified from the very beginning. The personal insolvency regime also is something that was codified since the commencement, that is in 2016. However, it got notified only in November of 2019. And I think it's very important for one to see that the relevance of this phased manner notification is understanding really the close proximity and the interrelation that the corporate debtors have with the personal guarantors. And from the way I see it, this is really a gradual willing acceptance that this phased manner is coming, because the everybody knows the financial implications of such a code are so vast that one requires a very gradual acceptance to it with lesser resistance. Because one of the financial implications, as we are all very well aware, is especially with regard to personal insolvency, is the credit profile that gets hit for a personal guarantor. And future credit profile of the personal guarantor, because here what we are talking about is under 94 or 95, a debtor or a creditor, as the case would be, in a case of a default. And here we are, as against corporate insolvency, the default here we are talking about is only 1,000 rupees. So the debtor or the creditor would file an application either itself or through a resolution professional. So it's very interesting to see that unlike the corporate insolvency resolution process, where after the admission stage a resolution professional is appointed, here there is an option of taking a resolution professional at the very outset, and there the insolvency process starts. I also see another thing as against the corporate insolvency resolution process, that like Misha pointed out, that an interim moratorium is issued. But here, in addition to that, I would say that there is a resolution professional report, recommendatory report that goes to the adjudicating authority, unlike where an objective determination is done by the adjudicating authority itself. So there was that short case of Moser Beer that happened, where Mr. Puri, Mr. Deepak Puri had unfortunately passed away, and they'd filed an insolvency against that person. And the resolution professional brought that to the attention of the adjudicating authority. And as a result of that, the personal insolvency came to an end there. So now when that recommendation has to be given, either it is an acceptance or a rejection, or the third, which has not been notified, is a fresh start. And that third process of a fresh start is a step ahead in terms of the court intervention being lesser. And after, of course, the report there is a lot of discussion going on as to whether at this stage, where the resolution professional is appointed in the interim, is there a requirement, in case an application is filed by a creditor, to hear the debtor at all, or will that be really in violation of principles of natural justice? And post that, Tarun, after the the insolvency, after the resolution professional is appointed, there comes the stage where there is a COC, and unlike again corporate insolvency resolution process, the debtor is the one who makes a repayment plan. With the consultation of a resolution professional, which has to then be accepted by 75% or 3/4 of the committee of creditors. So and which ends at a discharge order. Eventually, after it's been approved, it's placed before the adjudicating authority, and there is a discharge order. So the way I look at it is that where we commence the entire insolvency regime very aggressively with the corporate insolvency resolution process with regard to corporate debtors having a full adjudication by the adjudicating authority, which was the National Company Law Tribunal, we have come to a stage where court's intervention is a little lesser, with reliance on the resolution professional's recommendation being more. And the next, which we await, the fresh start, which is a waiver, that would result, that regime is even further where, after there is an admission, is that the resolution professional itself draws the entire repayment with the discharge, with the conclusion with the discharge order. So the way I look at it is that, like Bikash said, that we are 100% looking forward to the fresh start also being notified, so as to have an entire holistic view to resolution in its true sense.
Okay, thanks Ishna for all those points and sharing them with us. On this note, we will take a short break and we'll be right back. Welcome back. Just before the break, Advocate Ishna Kumar shared her points introducing the personal insolvency process. May I now go to Siddharth Srivastava from Khaitan and Company. Siddharth, your introductory comment on the show.
Thank you. Thank you. I think my co-panelists have already said a lot, so I'll not sort of repeat this, but I mean, just to sort of give you a little bit of background as to why and the reason, let me say that I think it's a welcome move. Because what the personal insolvency regime actually does is actually provides a codified, time-bound manner of a resolution of personal insolvency, which was not there in an apt form under the existing statute. So I think that is something which needs to be kept in mind when we are actually talking about personal insolvency, because the Presidential Town Insolvency Act and the Provincial Insolvency Act did not actually provide a very, very strict timeline to resolve the insolvency. And that was one of the reasons why the legislature thought that, the government thought that they should be brought into effect. And therefore, that's, I think, the biggest advantage of the personal insolvency code. And of course, I'm not going into the details of the procedure, which my co-panelists have already touched upon. So that's one thing. And also, because it is a time-bound process where a resolution professional is also involved, it has a great deterrent effect on individual guarantors or personal guarantors. They cannot take the system for granted. They know for a fact that if they're giving a personal guarantee to secure a particular debt of a borrower, then they cannot just renege on their promise of performing the guarantee, because there's a time-bound process. There would be a resolution professional who would be appointed. There would be a repayment plan. There's an adjudicating authority which is involved, and the entire process is, as I said, is being done in a time-bound manner. So therefore, that's, I think, the biggest advantage of having a personal insolvency regime. And also one more thing, the personal insolvency regime is not only to be seen from the prism of insolvency resolution, but also bankruptcy. So akin to a corporate insolvency resolution process, or in context of corporates, you have a corporate insolvency resolution process, and then you have a liquidation process. So the personal insolvency regime also talks about the insolvency resolution of an individual. And if that works out, great, there's a discharge order. If that doesn't work out, then the creditors have an option to file for bankruptcy, in which case, again, the process is akin to liquidation in context of corporate, where the assets of that individual guarantor can be sold off, and the proceeds of that assets will be distributed as per a particular waterfall under the IBC code itself. So that's something which is akin to what, as I said, in context of a corporate debtor. So therefore, it's a holistic code which not only talks about an insolvency resolution, but also a bankruptcy. And the effect is that both are time-bound. Even the bankruptcy process is a time-bound process, with a view to ensure that the creditors and the stakeholders get their money back to whatever extent possible, whether it's 50 cents to $1 or 90 cents to $1. So that's my opening remark in terms of why and how this code with respect to personal insolvency has come into picture. And I think it's a welcome move.
Thanks for that introductory comment, Siddharth. Now we move on to the examples part of our show, because mainly all businessmen want to know what happened to A or B with or without taking names, doesn't matter, because What we learned when we were researching for the show is that the personal insolvency process will also bring in the practice of good corporate citizens, because when you enforce these people to pay back the loans for which they have stood guarantors for, it sends a message to the industry to keep their books clean in that sense. Of course, we all have been privy to stories of companies, dummy companies being created, money being siphoned off way back to the promoters of those very companies. I mean, these are stories all of us know, how money is, in a sense, finds its way to personal private companies or promoters and their relatives. But not going in there, I would like to discuss examples today so as to make it clear where the personal insolvency system has been proven successful or what is its impact. Misha, if you could please start and share a few examples, and then I move on to the rest of the panelists.
Right, sure, Tarun. I don't know, it sounds like that I'm going to give good news to some of the personal guarantors and businesses and not so much of a good news for the bankers, at least in some of the cases I've seen. I think I mentioned the peculiar feature of, personal insolvency where there's an interim moratorium on the very filing of the application. And I think that acts so much in favor of personal guarantors and against the creditors wanting to enforce on the personal guarantee, that in many situations I find that going for a personal insolvency action against a guarantor is a less attractive option for a creditor than maybe even going for a summary suit or an enforcement in DRT. Let me explain why. I think the key is the fact that there is an interim moratorium, which I think really needs to be re-looked at, because it protects not the assets. The interim moratorium by very nature should be something that in the interim there should be status quo, which should protect the assets of the of the guarantor. Of course, if you want to also, as part of the interim moratorium, stop legal proceedings and stop enforcement of debt, that's a policy decision. But the fact that there is no bar on the personal guarantor dealing with his assets is a huge loophole, according to me. So in some of the examples that we've seen personally or witnessed in the courts is that the personal guarantors are in fact protected because of this interim moratorium. The moment the creditor has gone and filed, they are actually in a heaven, and they don't need to go to outside the country to in a tax heaven or protected. They're just protected by virtue of the law. Nobody can go after them. Nobody can enforce the debt. Nobody can continue with the legal proceedings. And after that, unfortunately, because of the delays in the system, in the judicial system, both in NCLT and DRT, as Bikash was also rightly pointing out, that we need to really think about whether DRT is even the right forum to do personal insolvency, because especially the COVID times have exposed that they do not have the necessary infrastructure to even deal with the regular banking cases, let alone the load of the IBC cases, right? So because of, and even NCLT has a huge pendency today. Because of that, we are not able to move forward, and the personal guarantors are actually able to come with one or other ways of just somewhere or other way, just delaying the admission of the insolvency process. So you have interim moratorium protecting them, but you're not successful with actually getting the admission of the personal, insolvency process. And many of the processes I have personally witnessed are in limbo. Initially, of course, the processes were in the limbo because they were constitutional challenge pending. That's understandable. The law has to go through that rigor and the test. It has gone through, and since May 21, it could proceed. But even when the NCLT or DRT could proceed with the matter, there is a delay from the stage of interim moratorium to reaching the moratorium, and then thereafter actually coming up with the repayment plan. The other loophole I find in the law is the fact that there's unlike this scheme of the corporate insolvency, which is relatively much more clearer than it is in personal insolvency. And we still have had huge litigation debating upon what, corporate insolvency resolution meant. But in personal insolvency, those areas are actually much more. For instance, one of the sections deal with the fact that the resolution professional may call for a meeting now of the creditors. Now, in which cases is a resolution professional not required to call for a meeting? I would assume it could be nothing else except where the personal guarantor comes forward and says, I'm willing to pay everyone, and there's no haircut involved, and there's no even reschedulement of payments. If that was the case, then there would never be a personal insolvency action, right? So it's very unclear why a resolution professional would not call for a meeting of the creditors. Once the other loophole I see in the law is the fact that there being no it's not really a loophole, but a area where it is possible to abuse the system, unfortunately, is because everybody comes and votes as part of the committee of creditors. There is no distinction between secured and unsecured. Neither there is a class voting. Because you don't have a class voting, then an unsecured creditor can also actually trump the secured creditors, then secured creditors will be forced to stand outside this resolution process. So these are some of the things which need to be tested and see how it will go.
Point well taken, Misha, and thanks for highlighting those two loopholes, if I may call that. And I'll go to Siddharth Srivastav for his intervention. Siddharth.
Yeah, so thanks. So I'll give you a little bit of data. So as per the IBBI data, more than 650 cases have been filed till December 2021 for initiation of personal insolvency. And 95% of those cases have been filed before NCLT. The balance 5% would have been filed before DRT. But most of these cases are pending, of course, as Misha and others have also said, that this is something which we haven't seen a successful resolution of personal insolvency so far. And when I say successful resolution of personal insolvency, yes, there have been cases where an application has been filed by either the debtor or the lender, especially the public sector banks. The NCLT or the DRT, especially NCLT, has prima facie taken a view that there exists a default, and they have basically asked the resolution professional to do the determination of whether to finally admit the application or not, which has resulted into interim moratorium. But there's no final sort of adjudication of that application. And even if there would have been a final adjudication of the application, at least I am yet to see a successful case of a personal insolvency which has resulted in value to the creditors. We are yet to see that. So to say whether the actual process is a success or not, I think we're still a little far away. The concept, as I said, is very good. The intent is good, but still it's early days to see how effective it is in practice. We have seen many cases though, but nothing successful as of now. It's still a work in progress.
Nothing successful.
Yeah.
Okay. Thanks for that point. I'll go to Advocate Ishna Kumar. Ishna.
So I think the personal insolvency saw the light with the case of Anil Ambani, where there was an admission by the NCLT Mumbai for a personal insolvency, which eventually got challenged before the Delhi High Court. There was no stay, but as you know, the co-panelists have said, that there hasn't been we haven't seen as to what is the end result of it. I mean, we haven't seen what we may call a discharge order or a failure of an insolvency so as to result into a bankruptcy. However, we've seen, in addition to Anil Ambani's case, the Videocon Venugopal Meghdut case, and then we had the Sanjay Singhal case, where orders have been passed with regard to there being a default and therefore a personal insolvency having been initiated against all of them. However, one issue I think that's being discussed, in addition to the practical aspects of DRT not having the logistics to go ahead with the adjudication of personal insolvency cases, I think there is a lot of discussion, and the law still, as I said, because it's a new dimension that's come in. So the law is still grave as to when would really NCLT be an adjudicating authority and when would DRT be an adjudicating authority. However, of course, there is recognition of the interrelation between corporate debtors and the personal guarantors, and with regard to that, there is that recognition that when there is a corporate insolvency process that is pending, then necessarily it has to go to the National Company Law Tribunal. However, the recent judgment of the NCLAT in Jajodia, they've recognized it even otherwise, which that is through Justice Ashok Bhushan, and one could say that that view would help in terms of taking care of the logistics. However, another view could be that would render the adjudicating authority as recognized by DRT to be an absolute obsolete and might be in the teeth of Section 179 as well. So I think we're still seeing the law in it, and that's been challenged before the Supreme Court. So it will be very interesting to see what the view the Supreme Court takes with regard to the jurisdictional aspect.
Thanks, Ishna, for the intervention. Today's closing comment goes to Bikash Jawar from Saraf and Partners. Bikash, your closing comment on the show today.
So I think personal insolvency, as to its utility, we will have to, it's still open to, finalization as to whether personal insolvency will serve any utility. As a banking lawyer, I would think that there are some benefits which will come. One of the key benefits of personal insolvency would be that the relevant individual would come within the scope of court supervision and would come within and his assets, his claims, etc., would come within the scope of court directions. Currently, that itself is missing, right? If one were to enforce a claim against an individual in a civil court, it takes its own time to kind of get admitted, and there is an entire issue of to what extent can without the intervention of the court, I cannot take any action against his assets. I cannot take control over his assets. I cannot seek details about his assets without the intervention of the court. Now, what the personal insolvency law does is it empowers the resolution professional to ask questions, right? And it obliges people to answer, right? So I think there will be some benefits, okay? But one of the concerns which I have in my mind is the actual financial utility of this to creditors, because let's say in all of these larger cases which are there where it is linked with the corporate insolvency, where the personal guarantors are linked to corporate insolvency, most likely if they had the cash, they would have done something to, in a way, help their businesses, right? A lot of these businesses were otherwise decent business. They just, didn't have the cash anymore. So what are you going to chase after? The guy may not even have worthy assets, or, even if he has worthy assets, he would have kind of pushed them in bankruptcy remote structures, right? So for instance, if he has assets stuck in a trust, whether his beneficial interest in a trust, okay, can actually be, claimed in bankruptcy. As Siddharth mentioned, bankruptcy is the natural corollary of personal insolvency if the guy is not able to pay up, right? But can I actually touch his beneficial interest in a trust? And we know promoters have, had the benefit of, good advice to, store their assets in appropriate habits, right?
Thanks so much.
So let's see how the utility is. Yeah.
Let's see what comes of the whole personal insolvency process, as they say. But I must say, a very engaging discussion today. Whoever watches this will find it really useful. I'm so happy that this part one on the personal insolvency process went so well. Each one of you who shared their opinions and their expertise on this, on legally speaking, today. I would like to thank Misha from Shardul Amarchand and Mangaldas, Bikash Jawar from Saraf and Partners, Advocate Ishna Kumar, Siddharth Srivastava from Khaitan and Company. Thank you so much for joining us on this issue. Looking forward to see you again. Thank you so much.
more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.